Let's talk about a Supreme Court case that didn't start with some abstract legal theory. Nope, this one started with a father's heartbreak. It's a story that forced the entire country to ask a really tough question about what actually makes a family. This is the story of Stanley versus Illinois.
Think about this for a second. Could you lose your kids, your own children, just because you never signed a marriage license with their other parent? For a man named Peter Stanley, this wasn't some far-fetched hypothetical. It was his worst nightmare coming true.
So our story kicks off not in a courtroom, but with a family tragedy, a loss that would end up sparking a massive legal battle that went all the way to the top.
For 18 years, Peter Stanley and Joan Stanley lived together. I mean, that's a long time. They built a home, a life, a whole world together, even if they never made it official with a marriage certificate.
And during those 18 years, they had 3 children. By any measure that really matters, they were a family. Peter was there, raising his kids right alongside their mother. He was their dad, period.
But then, Joan suddenly passed away, and in an instant, Peter's world just completely shattered. The state of Illinois stepped in immediately, but not to help him grieve. They stepped in to take his children.
And this right here is the part that is just so hard to wrap your head around. His children were made wards of the state. Poof, just like that, without a single hearing. No one asked if Peter was a good father, his ability to care for them, his history with them, his love for them. None of it mattered. The state just took them away.
So you've got to be asking, how on earth could this happen? Well, it wasn't some bureaucratic mix-up. It was the law in Illinois at the time. Let's dig into the statute that made it all possible.
Okay, so check this out. The law in Illinois created this totally unequal two-tiered system. For basically any other parent, married dads, divorced dads, even unwed mothers, the state had to prove in court that you were neglectful before they could take your kids. But if you were an unwed father like Peter Stanley, the law just assumed you were unfit. It made a blanket presumption. The moment the children's mother died, the kids were automatically considered dependents of the state.
And this wasn't some hidden fine print. The Illinois Supreme Court came right out and said it. In their ruling, they wrote that Peter Stanley's actual fitness as a father was, and I'm quoting here, irrelevant. The only thing that mattered legally was his marital status. Just incredible.
So Stanley decided to fight. He appealed his case all the way to the U.S. Supreme Court. Now, let's look at how Illinois actually tried to defend this law. What was their argument for treating unwed fathers this way?
So, yeah, why did this law exist? Well, the state argued it was based on what they saw as a practical, if maybe a little harsh, assumption about unwed fathers as a whole group. Their argument really came down to 2 key things. First, they claimed it was just reasonable to assume that most unwed fathers were unfit parents. They actually talked about a general disinterest from this group. And second, it was all about efficiency. It was a shortcut. By just presuming they were all unfit, it saved the courts a ton of time and money, which they argued was better for the kids in the long run.
But, the U.S. Supreme Court had a pretty powerful response to that whole efficiency argument. They said, the Constitution recognizes higher values than speed and efficiency. Basically, you can't just toss aside fundamental human rights because it's more convenient.
And that leads us right to the big decision. Let's break down the 2 major constitutional ideas the Supreme Court used to strike this law down for good.
First up, we've got the Due Process Clause. The court said, look, the right a parent has to the care, custody, and management of their own children is a fundamental liberty. And you can't have the government take away a liberty that important without a fair process. And a fair process means you get a hearing to make your case.
Then there's the Equal Protection Clause. This is all about playing fair. The court pointed out that Illinois gave hearings to every other kind of parent. By carving out this one group, unwed fathers, and denying them that same chance, the state was treating them differently for no good reason, and that's a textbook violation of equal protection.
So this is the real kicker. The law didn't just fail one constitutional test, it failed 2 of them. It was a 1-2 punch. The procedure was unfair, and the law itself was discriminatory. The state couldn't just assume unfitness, it had to actually prove it.
This quote from the court's opinion just sums it all up perfectly. You have to prove parental unfitness based on individualized proof. In other words, you have to look at the actual person, the actual father, not just slap a label on them and call it a day.
Now, to be fair, the decision wasn't unanimous. Chief Justice Berger dissented. He basically argued that the court was getting into state business where it didn't belong, and that Illinois was actually justified in assuming that, as a general rule, unwed mothers tend to have a stronger, more established relationship with their children than unwed fathers.
So in the end, Peter Stanley got his day in court. But what's the big picture here? Why are we still talking about this case? Well, this ruling had a huge, lasting impact on parental rights all across America.
Honestly, the legacy of this case is massive. It was a real game changer. It established that the bond between a parent and child is a fundamental right that's protected by the Constitution. It said you can't judge a parent's fitness based on stereotypes about their gender or marital status. It guaranteed unwed fathers the same right to a hearing as everyone else, and it sent this incredibly clear message: people's rights are more important than the government's desire for a quick and easy process.
And this quote, which the court used in its decision, really gets to the heart of it all. It's his beautiful idea that raising a child is first and foremost the job and the right of the parents, and the state's role isn't to get in the way of that unless there's a very, very compelling reason.
And that really leaves us with one final big question. The state of Illinois thought its law was just an efficient shortcut. The Supreme Court saw it as a major violation of personal freedom. The case of Stanley versus Illinois forces us to keep asking a question that's just as important today. Where do we draw that line between what's efficient for the government and what's essential for protecting our individual rights?